Hello, class. Uh, Today, I would like to discuss the Texas court system. If you have your key terms in front of you, then that would be helpful uh, when I go over the key terms. But if you don't have them, then you can always go to Canvas and upload them. But hopefully, you will get uh, information, enough information that really you won't need your key terms in front of you. Uh, First of all, about the Texas court system, we have what is known as a dual court system in the United States, which means that the federal government has a court system which consists of the Supreme Court, the Court of Appeals, and the District Court. And in Texas, or all 50 states, Texas being one of them, there is a court system, a separate court system. You have the District Court, Courts of Appeals, and you have the Supreme Court and the Court of Criminal Appeals. In in Texas, you have certain courts that handle what are known as criminal cases, and you have courts that handle civil cases. Now, I would like to go over these key terms. I like going over key terms because I feel that if you know these key terms and you know how they apply, then you know the subject matter that we're going to go over. And you should have no trouble on any quiz or any exam. Civil case. What is a civil case? Well, by the way, we have two types of cases. We have civil cases and we have criminal cases. Civil case is a situation where you have a dispute between two individuals. A criminal case is also a situation where you have a dispute between two individuals, but when it comes to a criminal case, one of those individuals happens to be the government. The government is accusing another party of violating some law. Now, I'm going to talk mostly about criminal cases because I don't know. I consider, well, civil cases are just as important as criminal cases, but I want to talk more about criminal cases because I feel like if a person loses a criminal case, they're going to suffer more consequences than if they were to lose in a civil case. Now, as far as civil cases are concerned, people can be accused of two different types of crimes. One is known as a misdemeanor. A misdemeanor is a less serious offense, such as minor theft, meaning theft, theft in the amount of less than $50, or first-time DWI, traffic violations. All of those are considered misdemeanors. And misdemeanors are punishable by a fine, paying a fine, or incarceration or being in jail for a time period not to exceed, for a time period of under a year. Under a year. That is a misdemeanor. Misdemeanor would be punishable by that. Now, a felony is a much more serious offense. Examples would be, of course, murder, robbery, rape, sexual assault, all crimes. Such crimes are punishable by death or imprisonment for over a year. Imprisonment for over a year. Well, at least for a year or over. A felony would be punishable by imprisonment for a year or more. Now, for these two different types of crimes, we have to go to court. The parties have to go to court. Parties in a civil case and parties in a criminal case, they have to go to court. Certain courts that they can go to. First of all, let's say that someone wants to start a case. Someone wants to file a lawsuit against someone. Or the government in a criminal case wants to prosecute someone for committing a crime. They have to go to a court of original jurisdiction. What is a court of original jurisdiction? It's a court where you start the case. A court where you parties lay out their sides to the case. And the place where the court makes a determination of the facts. Exactly what happened in these cases. The facts. That's where you have the juries. Juries are charged with making a finding of fact. Exactly what happened in the case. That's where you have the evidence. Evidence is submitted to the court of original jurisdiction. Another name for a court of original jurisdiction is a trial court. So, trial court, facts, you have evidence, you have witnesses give testimony. So, you have all of that happens in the trial courts. And the trial court makes a determination of the facts in the case, what happened. And after the determination of the facts is made, then the judge of the court, of the trial court, will apply the law. So, make a determination of the facts. Jury, usually the jury makes a determination of the facts, and the judge at the trial court level applies the law, appropriate law, and determines what will happen or what should happen in that particular case. Now, what if a party loses in the trial court? What if a party loses in the trial court? If that happens, then that party has a right to appeal to a court of appellate jurisdiction. The appellate court will make a determination as to whether or not the law was followed in the trial court. Did the trial court follow the law? They don't try to relitigate the case and try to come up with a determination of the facts. Usually they don't do that unless they're doing what is known as a trial de novo, and I'll be talking about that later. But they usually make a determination as to whether or not the correct procedure was followed in the trial court. Did the trial court follow the law? Now, like I said, I would like to emphasize more the criminal court system because of the fact that I feel that people who are convicted in the criminal court system, they would face more consequences than a person who loses a case in a civil court. Usually a person that loses a case in a civil court, it's just, well, not just money, but it's money. Usually it's money that's at stake. But in a criminal court, not only money could be at stake, but a person's property, a person's liberty, or even a person's life could be at stake. So, getting back to criminal cases. Before the government, which is one party, can try a person, and a trial person for committing a certain crime, that person has to be formally charged with that crime. That's mandated by the Texas Constitution. And so a person, before that person can be charged with a crime, that person has to be either indicted, if it's a felony, accused of committing a felony, or that person has to be charged through information or an administrative hearing before a judge. Usually that's usually utilized for misdemeanor cases. Now, in order for a person to be indicted in a criminal case, indicted for committing, not indicted in a criminal case, for committing a felony, that case has to go before a grand jury. A grand jury in Texas usually has 12 members, and 9 members of the jury has to vote to indict that person. If 9 members vote to indict, then that's a true bill, and that person can be made to stand trial. If less than 9 members vote to indict, then that is known as a no bill, and that person does not have to stand trial. But let me tell you something about grand juries. Grand juries and their relationship to the prosecutor in the case. Usually, if the prosecutor wants the grand jury to indict, then that grand jury will indict. That is usually the case. Now, I'm pretty sure there have been exceptions to the rule, but the rule of thumb is if the prosecutor presents a case before the grand jury and asks that grand jury to indict, then that grand jury will indict. So usually, if the grand jury does not indict, that means that the prosecutor did not want the grand jury to indict. So let's say the grand jury indicts a person for committing a crime. That person has to be made to stand trial. That person has to have his case heard by a judge, or if he or she chooses, a jury. Such a jury is known as a petit jury. Petit jury determines whether or not a person is guilty of a crime. Speaking of that, going back to grand jury indicts a person. That means that the grand jury has determined that there is enough evidence to put that person on trial for committing that particular crime, alleged crime. Petit jury, on the other hand, determines whether or not a person is guilty of a crime. So, if you're indicted by a grand jury, that does not necessarily mean that you are going to be convicted of committing a certain crime. It only means that you are going to be made to stand trial, and during the trial is going to be determined whether or not you are guilty of a crime. So grand jury does not mean you're guilty. Grand jury indictment does not mean that you're guilty. Petit jury conviction does mean that you're guilty. Who serves on a grand jury? Grand jury is a group of people that are chosen by a particular court. Usually chosen by a court. Petit jury is members of the petit jury are chosen also by the court, but what happens is that they are chosen from members of the general population. How does that happen? Well, what they do is they look at voter lists and they look at driver's lists. And from that, they're able to get the names of potential juries. Now, it used to be that they would only look at voters lists. And some people, in order to avoid serving on the jury, they would just not vote. But that has changed. That has changed because now the people in charge, the courts, are able to look at both voter lists and driver's lists in order to come up with names of people to serve on juries. Now, in every case, you have two parties. And this is criminal and civil. Both criminal and civil. But, okay, in a civil case, you have the plaintiff versus the defendant. The plaintiff sues the defendant, and the plaintiff has the burden of proof, and the plaintiff has to win his or her case. But in a criminal case, you have the government on one side and you have the defendant on the other side. And the government has to prove his or her case. And by the way, the government is usually, the government is represented by the prosecutor. That could be a DA in most instances, or the county attorney in some instances. Now, so prosecutor presents his or her case against the defendant during the trial, and afterwards the jury makes a determination of guilt, whether or not the defendant is guilty or not guilty. Or sometimes if the defendant wants to have a trial before a judge, then the judge will make that determination. And then the law will be applied to that individual if that individual happens to be convicted. If that individual happens to be found not guilty, then the defendant is free to go. Different types of courts in the court system in Texas. And some of them are trial courts, and some of them are appellate courts, to name a few. One is known as the municipal court. The municipal court is a local court that hears cases pertaining to violations of city ordinances. Mostly, the overwhelming majority of the cases heard at the municipal court level are traffic cases, running a red light or speeding, things of that sort. Judges on the municipal court are usually appointed usually by the city. And municipal court cases are usually Class C misdemeanor cases. Usually Class C misdemeanor cases, criminal cases, are heard at the municipal court level. Class C misdemeanor means, in effect, that you don't go to jail. You simply pay a fine. Next, there's the Justice of the Peace Court. Justice of the Peace Courts can also hear Class C misdemeanors. Also, they can hear small claims. They're known as the Small Claims Court. You've probably seen these courts on TV, the People's Court, or Judge Judy, or Judge Brown. These courts, individuals can literally be their own attorney. Usually that's what happens. They come to court and they present their own case. Justice of the Peace. Justices of the peace are elected individuals who do not have to be lawyers. So they can hear Class C misdemeanors. They can hear small claims. Also, another function that they perform is issuing arrest warrants. The officials, they suspect someone of committing a crime. They go to the Small Claims Court or the JP Court, not the Small Claims Court. They go to the Justice of the Peace Court and they present probable cause that a person has committed a certain crime. So, JP, Justice of the Peace Courts, hear Class C misdemeanors, hear small claims, and they can issue arrest warrants. And like I said before, vast majority of the cases that are heard I'm sorry. I'm sorry. I made a mistake. I'm sorry about that. They hear small claims, class C misdemeanors, and they can issue arrest warrants. Next, we have the county courts. They can either be civil or criminal. And of course, civil courts handle civil cases, usually someone suing someone else. And you have criminal courts, county criminal courts. These county courts, are two different types of courts. One are known as constitutional county courts, and other courts are known as county courts at law. Constitutional county courts created because of the Constitution. County courts at law created because of the legislature. Now, as far as these county criminal courts are concerned, they hear Class A and B misdemeanors. Criminal county courts, they hear Class A and B misdemeanors. Next, you have district courts. District courts are the chief courts of original jurisdiction in Texas. They are the chief trial courts. Those are the courts that hear the serious crimes, the felonies. They are heard in district court. In some other states, they're referred to as superior courts. So call them district court, chief trial court. In other jurisdictions, they are known as superior courts. In New York, they are known as superior courts. And they hear the serious cases, the felonies. The felonies are heard in district court. Court of record. Court of record. This only refers to the fact that a record is kept in a court that conducts a trial. A record of the trial is kept by the court that's conducting the trial, district court, or the county court, or the JP court, or the municipal court. Court of record. Trial de novo. Sometimes, I know I mentioned before that usually when you appeal a case to an appellate court, they do not try to relitigate the case. They do not retry the case. Try to make another determination of the facts. However, there are some situations where at the trial level, no record was kept. Some trial courts do not keep records. This usually happens when a traffic case, a trial is conducted with regard to a traffic case. You lose a traffic case, you are entitled to appeal. But what if that court did not keep a record of the trial? In a situation like that, the court that you appeal the case to, that court will give you another trial. That court will conduct another trial. And usually the court you can request a trial de novo for just about anything. A court can conduct a trial de novo for just about any reason because a record was not kept at the lower court. A record was not kept at the lower court. So the appellate court, for instance, you lose a traffic case. You can appeal. You can appeal that case, the decision in that case, to an appellate court. And in this instance, that would be the court, the county court, the criminal county court. You can appeal the case to the criminal county court, and the criminal county court, no record below, criminal county court will conduct a new trial. And like I say, you can request a trial de novo for any reason. Court of Appeals. Court of Appeals. If you lose in the trial court, like the district court or the county court, then you can appeal to the Court of Appeals. If you lose a civil case, then you can appeal if you lose in a civil case, then you can appeal to the Court of Appeals. Criminal cases, Court of Appeals. Civil cases, Court of Appeals. There are 14 courts of appeals. 14 courts of appeals. Now, what the Court of Appeals will do is they will review the record of the trial court and make a determination as to whether or not the law was followed. Now, what if you're lost in the Court of Appeals? What do you do then? You can appeal your case to the highest court for criminal matters, and that would be the Court of Criminal Appeals. The Court of Criminal Appeals, a court of appellate jurisdiction, it has 9 judges sitting on that court, and they can hear the appeal from the Court of Appeals. Now, what if there was a case whereby a person was convicted in district court and that person was sentenced to death, was given the death penalty? And the defendant wants to appeal. Really, if it's a death penalty, there's automatic appeal. Automatic appeal. That appeal would not go to the Court of Appeals. It would go directly to the Court of Criminal Appeals. Now, if it were a regular criminal case like theft, then, let's say a person was convicted of theft in district court, then the case could go to the Court of Appeals, and then if that person loses, then that person can appeal the decision to the Court of Criminal Appeals. What about a civil case? What about a civil case? Let me briefly touch on the civil case, even though I'm saying I'm concentrating more on the criminal case. Civil case, person loses in district court, loses in a trial court, then the case can be appealed to the Court of Appeals. Loses in the Court of Appeals, then the case can be appealed to the highest court in the state of Texas for civil matters. That is the Supreme Court. The Supreme Court has 9 justices. So, criminal matters, highest court, Court of Criminal Appeals; civil matters, highest court, the Supreme Court. Judges sit on all of these courts. Now, I said earlier that municipal court judges, they are appointed. Most are appointed to their position. However, when it comes to all of these other judges, JPs, Court of Appeal judges, District Court judges, Court of Appeals judges, Court of Criminal Appeals judges, Supreme Court justices. How do they get their jobs? Primarily through partisan elections. They run in elections just like all other politicians in Texas. They campaign for their jobs. Partisan elections, what I mean by that is, as either Democrat or Republican. They run in primaries to get their nomination by either the Republican Party or the Democratic Party. And in the general election campaign, the Republican candidate opposes the Democratic candidate. They get their jobs through elections, partisan elections, which means that they have to go out and campaign and raise money. And believe it or not, they raise money from people that can later on have cases before their court. And this includes all courts, even the highest courts in Texas, the Court of Criminal Appeals and the Supreme Court. Something doesn't feel right about that, but that's the way it is in Texas. But Texas is not the only jurisdiction where judges are elected. Judges are elected in other states also. Now, I said before that these judges, they run in elections and they have to campaign just like all other politicians. And in Texas, at least, well, not just Texas, but a lot of them benefit from what is known as straight ticket voting. They happen to be a member of a certain political party. And because of that, they get elected. People don't know much about the qualifications of individuals to be judges. But if that person happens to be a Republican, the Republican candidate, then that person has a good chance of more than 50% of being elected because of that person's party affiliation and because of the fact that the Republican Party dominates Texas today. It used to be the same with the Democratic Party when the Democratic Party dominated Texas. And people that had the big D marked next to their name, they had a better chance of getting elected. Now, studies have been made about partisan elections, and one such study concerns the Supreme Court. A study was done in 2006, and it was determined that the Supreme Court was more likely, 7 times more likely, to hear cases that were brought by some of their largest contributors to their campaigns. They're more likely, 7 times more likely, to hear cases brought by large contributors, the Supreme Court. Something's wrong with that. Something's wrong with that. In some states, judges get their jobs. They're elected, but they're elected in nonpartisan elections. Nonpartisan elections are elections whereby the individual name appears on the ballot, but no party affiliation appears next to that name. That is what we have in local elections, municipal elections in Texas, like in Houston. The mayor, candidates running for mayor, there is no party's name that appears next to that candidate. Some states have nonpartisan elections for judges. I guess that's a little better than the partisan election. Now, some people vote for judges not simply because of party affiliation, but because of the fact that they recognize that person's name over other names that are on the ballot. Name familiarity. Usually, people elect individuals to be judges based on name familiarity. Now, I said before that most of the judges in Texas, district court judges and appellate court judges, they get their jobs through partisan elections. District court judges are elected to 4-year terms, and appellate court judges, including the Supreme Court and Court of Criminal Appeals, they get their jobs. They're elected to 6-year terms. But sometimes state judges, meaning district court judges and Texas appellate court judges, sometimes they get their jobs through appointment by the governor, through the appointive elective system. What happens is that the judge wants to fill a vacancy. Judges are able to fill vacancies on state court, meaning district courts and appellate courts, by appointing someone to be a judge. And then later on, if that person wants to remain a judge, then that person has to be elected by the voters of Texas. A lot of state judges get their jobs through this method. They are appointed by the governor to fill a vacancy. Now, of course, that appointment has to be approved by the Senate by a 2/3 margin. So the governor appoints a person to be a judge, and the Senate has to approve that appointment by a 2/3 margin. A point of elected system, like I said, a point of elected system is when the governor appoints a person to be a judge, and then later on that person has to run for election to remain on the bench. Run for election to remain on the bench. Texas elects most of its judges through partisan elections. Through partisan elections. However, there are some places that use what is known as the merit system. Another name would be the Missouri system. The Missouri system is a system whereby the governor first appoints someone to be a judge, and then later on that person has to run to be elected to remain on the bench. But the governor appoints someone from a list given to him or her by a group of professionals concerning which people are qualified to fill a vacancy on a court. And the governor chooses from that list and appoints that person, and then later on that person has to be elected to remain on the bench. Now, what's the difference? You may be asking, what's the difference between judges being appointed and judges being elected? Well, I, for one, do not think that judges should be made to running campaigns and campaign for their positions just like regular politicians. But that's my personal belief. Too much politics involved. Contributors appearing before judges whose campaigns they contributed to. A lot wrong with that. But in principle, what's the difference between appointed judges and elected judges? What if there were no politics involved, no political campaigns involved? Well, you're going to have campaigns. That's why you call them elected judges. Aside from the unseemly, I don't know. Aside from it, elected judges appearing to be unethical, the process seems to be unethical. Studies have been made concerning appointed judges and elected judges, and it's been determined that elected judges a lot of times they don't know what they're doing. They're not competent, as opposed to appointed judges. Appointed judges are more competent than elected judges. Better able to do the job of being a judge than elected judges. Because apparently they were on a list, like for instance in the merit system, they were on a list of qualified judges that was given to the governor, and the governor chose from that list and appointed somebody. And usually the governor is probably going to appoint somebody that he or she deems is capable of doing the job. So, appointed judges, usually more competent. Elected judges, what is the benefit? What's the upside or the good thing about elected judges. Responsiveness. Elected judges are usually more responsive than appointed judges. Now, is that a good thing or a bad thing? I said, what's a good thing? A lot of people may say that it's a good thing, but what if they're being responsive when it comes to matters that are... What if they're being responsive in determining what's wrong, what's right and wrong? A lot of times, the majority can be on the wrong side, and you are being responsive to the wrong side. But anyhow, appointed judges, usually more competent than elected judges. Elected judges, in fact, elected judges are usually the least competent of all of the other judges. Of all of the appointed judges, merit system judges, elected judges are usually the least competent. 14th Amendment. I have this as a key term because the 14th Amendment plays a lot with regard to our judicial process. 14th Amendment to the U.S. Constitution. 14th Amendment to the U.S. Constitution is the amendment that the U.S. Supreme Court utilized to make all of the Bill of Rights applicable to the states. Those first 10 amendments to the U.S. Constitution that talks about the rights that people have, the rights against encroachments by the federal government. Well, the Supreme Court has said that because of the 14th Amendment, people have rights against encroachments by state governments also. So that's why the 14th Amendment is very important. It's important for other reasons, but that is one of the reasons. One of the reasons. Like I've said before, I think the 14th Amendment is probably, I consider the 14th Amendment to be the most important amendment to, one of the most important amendments to the U.S. Constitution. Well, I consider it to be the most important amendment to the U.S. Constitution. Okay. Getting back to the courts in general. Courts make policy through their decisions. Their decisions can be policy, can be regarded as policy, as law. Courts make decisions on particular types of cases, and those decisions can affect other people besides the parties to the case. Because a lot of courts, they create what is known as common law. And what I mean by common law is that one court makes a decision concerning a particular set of facts. Another court, later on, same facts, they make the same decision. They follow the precedent. Stare decisis. Let the decision stand. Courts do this so that there can be some sort of consistency with respect to the law. Stare decisis, common law, following precedent. Courts also they make policy, but they're restricted in their policy making. They're restricted in their policy making because, for one thing, they can't make policy if they don't get a case. They have to get a case in order to make a law through a decision. Unlike the legislature, they can just pass a law. They don't need anyone, they don't need a case to make a law. The court has to have someone approach them with a case, and then they can make a decision and make a law. Legislature, no one has to approach them. They can simply make a law. So courts cannot initiate policy. Courts cannot initiate policy. Legislature can. Also, courts, when they make decisions, they are restricted. Restricted to federal law or state law, when federal statutes or state statutes, or federal court decisions, or previous state court decisions. They're restricted to a concept known as objectivity. Objectivity. They make laws only in accordance with the existing federal law or state law. Existing federal law or state law. Magistrate functions. Magistrate functions usually pertains to issuing warrants, ruling on actions for injunctive relief. A lot of times, JPs are called magistrates. Justices of the peace are called magistrates. One other thing that I would like to talk about when it comes to the Supreme Court and the Court of Criminal Appeals. Those are the two highest courts in the state of Texas. When it comes to civil matters, when it's the Supreme Court, and criminal matters when it comes to Court of Criminal Appeals. Now, let's say it's a criminal matter. What if a person loses in the Court of Appeals? What if a person is convicted and keeps appealing the case and loses the appeal in the Court of Criminal Appeals? What can that person do? Well, usually that person is that's it. Usually that is it. But what if the case touches on a federal matter and federal law gets involved? Then that person can appeal his or her conviction to the U.S. Supreme Court. The U.S. Supreme Court has the power to reverse a decision of the Court of Criminal Appeals. And what if it's a civil matter and that person loses in the Supreme Court, the Texas Supreme Court? Then that person can appeal the decision of the Supreme Court to the U.S. Supreme Court. The U.S. Supreme Court can reverse a decision, of the Texas Supreme Court. But, that is very seldom that's going to happen. Very seldom. Because usually it's clear if the case is concerned, if the case concerns state law or it concerns federal law. Usually it's determined at the beginning if it's federal law or state law. Now, sometimes some cases can involve both federal law and state law. A lot of times, most times, that's not the case. It's either state law or federal law. And if it's state law, you lose. And you lose in the Court of Criminal Appeals, then that's it for you. You lose in the Texas Supreme Court, that's it for you. But sometimes it can involve a federal matter, federal law. Then you can appeal to the court, to the Supreme Court, to the United States Supreme Court. But you can appeal, but that does not mean that the Supreme Court is going to hear your appeal. I've said this time and time again to people that appeal cases to the United States Supreme Court. My advice to them, I have 2 words for them. Good luck. Good luck. U.S. Supreme Court hears very little cases, a very small amount of cases, appeals that it receives, something like 1%. Only 1% of the appeals that the Supreme Court receives are actually heard by the court. So, I think I've covered the main points when it comes to the court system in the state of Texas. I've touched on the key points, talked about the different types of cases, civil versus criminal. And I've touched on the different courts, trial courts versus appellate courts, and the different types of trial courts or the different types of appellate courts. The municipal court, JP court, Court of Appeals, Court of Criminal Appeals, and the Texas Supreme Court. I've enjoyed talking to you, and you can now proceed to Canvas and take the quiz. It's a 25-question quiz, and not difficult. I don't believe that it's difficult. So, good luck. Take care.